On this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine, thanks.
All right, a lot to talk about as always, so let's get to it. And one of the things that several producers have are oil and gas leases, but there is a common problem that arises when the owner of, say, a fractional mineral interest either conveys or reserves a fraction using unclear language. Now, you're going to take a look at a recent Texas Supreme Court case to learn about the double fraction clause. So, first question I would have is, I guess, can you give an overview of a double fraction clause and what its impact is on future oil and gas conveyances?
Yeah, Greg, and I can imagine all the kids getting ready for school this morning that happened to have tuned into the station this morning and hear double fractions. They're suddenly turning the dial on the radio station to get to something else instead of talking about double fractions at 6 in the morning. This is a problem that can come up in particularly older oil and gas conveyancing instruments. For example, if I own an undivided 1/2 interest in minerals and I convey to you an undivided 1/2 interest in the minerals, what does that mean? Does that mean I gave you a 1/2 interest in all of my minerals or just half of a half? In other words, a fourth. And so when language gets in there that I'm conveying a half of an eighth or something like that, what in the world does that mean? Well, the problem has been for a number of years that a 1/8 interest was what was commonly retained by a landowner as a royalty interest. So everybody just retained an eighth. Well, over time, that 1/8 came to mean my whole interest. Interest in the royalties as well as interest in the minerals. In essence, 1/8 meant one. It didn't mean an eighth. So if I conveyed or sold the land to you and I reserved let's say a 1/2 interest in my minerals, what am I giving you? Am I giving you half? Am I retaining half? Or what is it? Am I retaining a 16th, which is a half of an eighth, and giving you 15 16ths? That's the problem with this. And so it's a language that's used in some of the older documents when 1/8 was common. And then we got to about the 1970s, and landowners got more bargaining power, and they started to they have the ability to reserve more than just an eighth. But that old language can still be there.
So let's talk about this Texas case that you brought up to learn more about the double fraction clause as well. Give us a recap of that case in Texas, and also put it into perspective what that all means with regards to this.
Yeah, this started back in 1924. You had one party called the Mulkeys that deeded their ranch to another party known as White and Tom, and they reserved 1/2 of 1/8 of all minerals and mineral rights. Well, after that, the conveyance was done in 1924. Both of the original parties conducted themselves as if they believed that they each owned 1/2 of the mineral interest. All of their successors in interest on both sides believed that and conducted themselves likewise. And that's the way they treated the payment of the royalties over a long period of time. Well, you get to 2012, so we've gone, 88 years from 1924 with no problems. But in 2012, an energy company drilled a well and paid both the successors in interest to the Mulkeys and the successors in interest to the original buyers, White and Tom, equal 1/2 shares, just like it's been done for many, many, many decades. Well, the successors to the White parties filed a trespass to title action. They claimed that the 1924 deed reserved in the original seller and all their successors only a 1/16 interest, 1/2 of 1/8 of the minerals, and therefore they should be entitled to 15/16. Now, what made this a big deal is we're talking $44 million in oil royalties. This is a big deal. And this goes through the court system and the trial courts and the trial court and the appellate court down in Texas said, yeah, that's right. Half of an eighth is a 16th, and that's what was reserved. You gave away 15/16, and it gets to the Texas Supreme Court, and they said, now, wait a minute. Yeah, this has given rise, this double fraction clause over the years has given rise to what's become known as an estate misconception theory. But, the parties looked at this and treated themselves as if it was a retained one-half interest for 9 decades. And we're going to take that into evidence, and that's pretty compelling that what the intent of the parties originally was the retention of a half of a full interest and giveaway of a half, not 15/16, transfer of the half. And so that's how the case came out. But the point is that the use of that double fraction clause back in 1924 results in a Texas case in 2023 involving $44 million. We just should stay away from the use of those types of clauses.
So can we expect this type of situation to come up, or I guess maybe the better way to put it would, if this happens in other states, would you expect that same result?
Well, not necessarily. This is all governed by state law and court cases. And I think in Kansas, a royalty deed is normally interpreted in accordance with the evidence that concerns usage over time by the parties involved, along with other relevant evidence. And we've got some cases going back. I can cite you one back in 1927, where the court said, the term royalty has to be construed in accordance with its well-known meaning, and it's not appropriate to look to custom to define that term. So the Kansas courts, for a long period of time, and other courts have followed that 1927 case in Kansas, they have clearly defined what royalty means, what a mineral interest means. They will look to the intent of the parties, but a lot of times the Kansas courts are going to say, well, what you stated is what we're going to follow, as long as it's not completely out of bounds with what the well-defined meaning of that term is. So we probably, on this case, the Texas case, we might get the same result in Kansas, but by virtue of a different path. But that may not always be the situation. So I come back to what I mentioned a moment ago. When in drafting things, we as lawyers should mean what we say and say what we mean, and clearly draft things. And I think the point on this, stay away from these double fraction clauses. Be very precise in what you're reserving and what you're conveying.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us. And Roger, we move on. Federal law has established procedures that a railroad must go through when they're abandoning a rail line and its corridor itself. But there's been a couple of recent cases highlighting the issues that can arise for adjacent property owners when a rail line is abandoned. It's a term called rail banking. And let me ask, what does the whole concept of rail banking involve?
Well, as you indicated, Greg, it's that process that allows a railroad to negotiate with some other entity, which would then assume the financial and managerial responsibility for the corridor by operating a recreational trail. But before the trail operator can start negotiations with the railroad, it has to file a rail banking petition. So it's a federal law. This is a federal procedure that has to be followed. And the trail operator has to state that it's going to be willing to assume full responsibility for managing the right-of-way, assume any legal liability for the transfer or use of the right-of-way. They have to pay any and all taxes on the right-of-way. And they have to acknowledge that the land will remain subject to possible reconstruction and reactivation of the right-of-way for rail service. Now, that's never happened, but that's the purported purpose of the entire Rails to Trails Act in the first place. Well, we want these corridors to remain corridors for usage of a rail line if we ever have to put them back in service because of national emergency or war or those types of things. That's the whole idea behind it. But it creates a bunch of issues when the rail line stops operating a railroad and a trail goes in, a recreational trail goes in. It creates a bunch of issues for farmers and ranchers and adjoining landowners.
And so what are some of those issues that you would talk about that it creates for those who are abutting landowners to that?
Well, one would be maintenance of a fence to fence off the corridor. Of course, trash. If you've got people going up and down the trail, there's going to be trash. There's going to be noise. Civil liability. What if I've got a Texas Longhorn steer that wanders up near the fence that's along the corridor? Now there are kids recreating with their families along the trail. Just a whole host of concerns. And then a big one for farmers and ranchers is, well, wait a minute. Shouldn't that corridor that's adjacent to me come back to me in terms of me owning it once the railroad stops using that line for rail purposes? So that the takings issue, since this is a federal government program, if that should have come back to me and it didn't, then they take some of my property now that I should be compensated for under the takings clause of the Fifth Amendment.
So of this taking issue, how does the corridor itself revert to the abutting landowners?
Well, the question is whether it will, and really there's a two-part analysis to that. We first have to determine what the railroad actually owned. Did the railroad own a fee simple interest in that corridor, or was it just an easement? If it was fee simple, then they can do whatever they want with it. They have outright ownership of it. They can transfer it to whoever they want to. There's no property interest to revert back to the abutting landowner. Now, if it was an easement, which is likely, not always, but it's common, then the question is we have to look at the terms of the easement and what does it say if the railroad ceases operating a line. You know, what is the language used to describe commonly what's used as railroad purposes? And it is a trail within the scope of being a railroad purpose. And we just had a recent case on that came out of Missouri, and that was exactly what the court determined that had happened, was that the railroad had an easement. It was an easement for railroad purposes. A trail went in. The land did not revert back to the adjacent owners. And the court looked at that and they said, now, wait a minute, operating a trail is not within the definition of railroad purpose. That's not what was thought of even at the time that the grant occurred. And that land should have reverted back to all of those abutting landowners. And so it was a federal takings case decided by the U.S. Federal Circuit. It went through the federal claims and into the Federal Circuit. And the issue now is, well, how much of those landowners are going to be paid? And so that's where the case is at right now, is determining the amount of compensation. So really, it's a multi-step process. Determine what the railroad owned. If it was an easement, look at the terms of the easement. Does it say that the eased property, the corridor, will revert back upon the failing of the use condition that's contained in the easement? What happened, is that outside the scope of the easement such that a reversion should have occurred? Then you might have a takings issue. Then you're going to have to establish what the value of it was that was taken from you.
Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, is joining us on the Ag Issues program. Something we don't talk about very often on this program is common law marriage, Roger, and you have a Kansas case that is brought up there, and this is a simple question, but I don't think I know the answer. What does it take to have a common law marriage here in the state of Kansas?
Well, it's more than just shacking up, Greg. There are some requirements that are required. And this is a case that just came down from the Kansas Supreme Court last week, and just a few days ago. And what you had was a couple that asserted that they had a common law marriage. And the problem was that the husband, I'll put husband in quotes because we haven't answered that question yet, he died. And so there's a whole host of issues that come up after death in terms of bank accounts and land ownership and taxes and all of that, and things that a spouse would be entitled to that a non-spouse would not be entitled to, certain rights. And so she said, well, we've been living together 7 years, and so therefore we're automatically spouses. We're married. That's a common law marriage. And not so fast. There's really a three-part test under Kansas law. And you have to have, of course, legal capacity to marry. There has to be a mutual agreement or an agreement that you are married. And then you have to conduct yourselves as if you were married and hold yourselves out to the public as a married couple. So those last two are one requirement in and of itself. So here, the couple lived together. They paid all their utilities under the same name. They made joint charitable contributions. They had a joint savings account. They owned multiple pieces of real estate together. They were listed as each other's beneficiaries on IRA accounts. They called themselves husband and wife at family events and in social settings. They went to medical appointments together. And ultimately, the court said, yeah, that's pretty strong evidence that they are married.
Okay, Roger, we got one more thing we want to discuss. This is talking about required minimum distributions, and this would be from certain retirement accounts that are taking place. And probably the first question we should start with is the type of retirement plans that would be subject to an RMD.
Well, let me answer that quickly by saying the one that's not, and that's a Roth. Roth IRA accounts are not. The funds don't have to be withdrawn during life, but the beneficiaries of a Roth are subject to the RMD rules. Now, the other accounts, an IRA, a traditional IRA, a simple IRA, a SEP IRA, or any type of retirement plan that's through an employer, for example. Now, the employer one might have some exemptions to it, but your basic traditional IRA and your simples and your SEPs are going to be subject to the age requirement as to when you first have to start drawing funds out.
And excuse me, how exactly are the RMDs calculated?
Well, once you turn 72, so the rules have changed recently, but when you reach 72 during a year, you've got to start taking out, you got to receive your first RMD, and that has to be by April 1 of the following year. Now, that's going to change to 73 if you reach age 72 after 22. But the way that it's calculated, IRS has a nice publication, Pub 590, that gives you assistance in computing the RMD, and that has the RMD tables in it that are used to calculate it. Basically, you're going to locate your age in an IRS uniform lifetime table, find your life expectancy factor in that table corresponding to your age, and then divide your account balance as of the end of the prior year by the current life expectancy factor. So the pub that people need is IRS publication 590. Study that, and you'll be able to figure out how much you have to withdraw from your retirement plan. Or if you have multiple plans, you can withdraw a certain amount from each plan as long as you're getting the minimum amount that's required to avoid the penalties.
But I would think your financial and or tax advisor would definitely be a resource to use there if you have any confusion on that whatsoever.
Yeah, indeed, and that's particularly the case, Greg. If you have multiple accounts, I think it's probably best to consult with the financial or tax advisor to help you determine what your best withdrawal strategy might be.
All right, and Roger, all the topics that we discussed, they can find on your blog?
Yep, that's washburnlaw.edu/WALTR.
Right, sounds good. Roger, as always, very much appreciate it. Thank you very much.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.